the hearing in the Investec appeal.
Morning. Good morning. May it please your Lordship, I am now coming on to the response, subject to Lordships, on the former trustees to the BVI company's restitution appeal. And you will have seen from our case, our written case, which is in the appeal documents bundle, volume 2, tab 32, that it's covered at pages 45 to 65 there, or in the MS, 14195 to 14215. My Lords, you will have seen that the former trustees have what I might call 5 defences. The first, in our primary case, is that there is no room for Oscatello's claim to restitution based on unjust enrichment, because the payment of 39 million odd by Oscatello to Kaupthing in discharge of the former trustee's debt was made pursuant to contractual obligations between Oscatello, Kaupthing, and the former trustees that were regulated by the Oscatello restructuring documents. There was a tripartite contract, and one of the obligations under it was that Kaupthing and Oscatello would enter into what's called the overdraft loan agreement in the Statement of Facts and Issues, or it was called in the framework agreement the Iceland loan. There is a subsidiary part of that argument, which is that even if there was no enforceable obligation that the former trustees could compel Oscatello and the Kaupthing to go ahead with the overdraft loan facility and to then for it to be used by Oscatello in repayment of the debt of 39 million, the fact that even in those circumstances there is no scope for restitutionary relief against former trustees because there is a general policy underlying restitutionary relief that it will be refused where the benefit is a result of the claimant's services rendered pursuant to a contract to which the defendant was not a party. And that will require me to show your lordships the passage in MacDonald and Costello which decided that. The third element of the third defence of the former trustees is that even if one accepts that free acceptance as a principle could be an unjust factor supporting a claim for restitutionary relief, on the facts of this case, when properly examined, the former trustees and Oscatello had no expectation that the former trustees would have to pay Oscatello back £39 million after Oscatello had discharged the former trustees' debt to Kaupthing. That depends primarily on analysis of the facts, which are set out in much, much more detail in our written case. The fourth defence is the defence of change of position. The former trustees transferred valuable shares which in the framework agreement were said to be worth £264 million, to Oscatello in the expectation that Oscatello would discharge the debt of 39 million to Kaupthing. And then fifth is our defence based on Article 32(1)(a) of the Trust's Jersey law. The former trustees say that if, contrary to the four previous defences, they are liable to Oscatello in restitution, that is a liability which they're only liable for in their representative or trustee capacity, not in a personal capacity, because the liability arose out of a transactional matter in which the former trustees were acting as trustees of the TDT. So those are the matters on which I to address your lordships. My lords, the background to the framework agreement and the overdraft loan agreement which led to the discharge of this debt of 39 million that the former trustees owed to Kaupthing is conveniently summarised in the Statement of Facts and Issues, paragraphs 15 to 31. Your lordships will recall that immediately prior to the funding of the Cengiz Discretionary Trust on the 24th of August 2007, I think your lordships were given a separate document, the Statement of Facts and Issues. I can see my Lord Carnwath's got it.
Well, what paragraph?
It's paragraphs 15 to
31.
To 31.
Thank you.
Your lordships will also be aware that the assets which were held within the Cengiz Family Trust, notionally for the benefit of Mr. Robert Cengiz, were companies, which we've called the TDT companies, because they became the TD companies, most of which invested in public equities in companies like Sainsbury's, Summerfield, Mitchells and Butler, well-known quoted companies, and they invested not by buying directly, but buying contracts for differences, and the arrangements for contracts for differences meant that they had to have margin accounts with their banks, or rather with those parties who provided them with contracts for differences. And the amount that had to be deposited in the margin accounts was related to the value of the underlying public equity holdings, the value of the shares in Sainsbury's or whatever. So if the value of the shares in Sainsbury's fell, then the margin account had to be topped up, and in order to top up the margin account, it was necessary to borrow money from Kaupthing. And on the 20th of August, as a result of collapse in equity markets, the trustees had to arrange an emergency loan of 100 million from Kaupthing, and that led to what's called the 20th of August loan agreement. That became an obligation of the trustees of the Cengiz Discretionary Trust when the TDT companies were appointed to the trustees of the Cengiz Discretionary Trust. And over the period between August 24th, 2007 and the middle of November 2007, the facility that Kaupthing had given of 100 million was drawn down, and it proved to be insufficient to cover all the margin calls, so that by the middle of November, that facility had been drawn down to the extent of 122 million, beyond the 100 million originally agreed. And this reflected the fact that public equity markets were continuing to be volatile and falling. So it became necessary to renegotiate with a number of lenders, but principally Kaupthing in Iceland and Kaupthing in Luxembourg, to create further funding to keep the ship afloat, because the borrowers could at any time have exercised their rights of enforcement and compelled sale of the contracts for differences, which in a falling market could have been very expensive indeed, particularly since these were such large holdings that they had, and they could have been market-moving events. Now, that was the reason why this was important and urgent for, identified by the trustees' investment advisors, R20, as something which had to be sorted out with Kaupthing Bank. And your lordships will have seen, both from statement of facts and issues and also from the written case that we prepared, that the basic idea was that all the debt, instead of being debt of the former trustees and a number of companies, would be consolidated as a debt of Oscatello, which prior to December 2007 hadn't been a trading company. The trustees would transfer their shares in the TDT companies to Oscatello, so that Oscatello could provide security to Kaupthing for a new facility of £371 million. And in addition, new money would come in, described, I think, as mezzanine debt, of 150 million through two participating profit loans, 75 million from ISIS, which was a subsidiary of Kaupthing, and 75 million from another investor called New Ortland. And the arrangements contemplated that the existing debts, particularly of the former trustees, but of other companies like Thorson, would be discharged out of the new facility from Kaupthing to Oscatello. So with that background, can I please take you to the framework agreement, which was the result of the negotiations by R20 on behalf of the trustees and Kaupthing. And your lordships will find that in the core bundle, volume 2, at 543, and 543 is the MS number 2. And just to remind your lordships who the parties were, this on the frontis page.
Sorry, the page again?
543, man. There were 7 parties. There was the trustees of the TDT. There was Kaupthing Bank. There was ISIS, which was its subsidiary. There was New Ortland, who were outside investors. There was Eliza, that was a 100% owned company of the TDT. Oscatello, which was similarly within the TDT. It was 100% of its shares were owned by Eliza, and Eliza was 100% owned by the trustees. And then Silverville Limited, which was another 100% owned company of the TDT. But it as a result of the shareholding structure within the TDT, there were some subsidiary companies whose shares were partly owned by Silverville and partly owned by the TDT directly, but that doesn't affect the analysis. Going over the page to page 545, your lordships see the recitals, the parties wish to set out the terms on which they will invest in a new corporate structure to hold certain interests in or reference to publicly traded and private companies, which interests are currently owned by certain members of the TDT group, the companies. This is called the transaction. And then you will see at C, as at the date hereof, TDT and Silverville are the ultimate beneficial majority owners of the companies and have agreed to transfer, or in the case of TDT, procure that Silverville transfers their shareholdings in the companies. And that's defined as the shares. My lords, the shares, there were 11 companies whose shares were transferred. They're listed in Schedule 1. We don't need to look at that. And they were to be transferred, this is the key point, to Oscatello, and then subsequently TDT and Silverville will transfer to Eliza their shares in Oscatello in consideration for shares in Eliza, in each case subject to the terms and conditions of this agreement. So quite clear that the transfer that the TDT was going to make of shares was subject to the terms and conditions, and that means we say all the terms and conditions of this agreement. At D, one sees the recital that Kaupthing is ultimate beneficial owner of ISIS. Going to 546, my lords, my learned friend has already read the definition of business. The point to note is in the penultimate line. It refers, or last 3 lines, it refers, one of the aspects of the business was advancing an operation of the Iceland loan. So the Iceland loan was part of the business which was contemplated by this transaction. I think they can see it's all right. Thank you. Yeah, that's great. Going on to page 549, one sees the definition of the Iceland loan, and that means an overdraft loan agreement between Kaupthing as lender and Oscatello as borrower, dated on or about the date of this agreement. We'll come back to that, and we'll have to look at it. That's for your note at MS 605. And it's referred to in the statement of facts and issues as the overdraft loan agreement.
No, we have seen these things.
I know, my lord, but I think
I think we should see them a second time.
I think we should, to be sure that we construe them accurately, my lord.
Right.
Yes. 551's definition of the shares, which are the shares in the 11 companies. Could I ask your lordships to bear in mind this figure, the TDT equity amount? It's going to be a figure which features again in the hearing this afternoon on G3. It means the 264 million odd, together with any initial amounts contributed to or invested in Eliza Oscatello by the TDT. The transaction documents include, if you see that definition, include the Iceland loan. You'll need to bear that in mind later on when reading the agreement. Page 553 contains the clause that just remind your lordships that clause 3 required Silverville and the TDT on and subject to the terms of this agreement, and subject to clause 4.1, which dealt with completion. I'll come back to this. So their obligations are all subject to what was said in 4.1, to transfer their shares in the 11 companies to Oscatello on completion, free from encumbrances. And at D, the obligation was to procure that Oscatello promptly grants the Oscatello share charge. That was a charge by Oscatello over the shares it was acquiring from the TDT companies in favour of Kaupthing, and these are the crucial words, a security for all of Oscatello's obligations under the Iceland loan. So the purpose of the transfer of shares by the former trustees to Oscatello was to enable Oscatello to charge those shares a security for Oscatello's obligations under the Iceland law. In other words, the new 371 million facility was going to go to Oscatello from Kaupthing, and that could only be done with the share transfer. At 3.2, one sees the clause upon which BVI companies stake all, and this is a recital or a statement that the consideration payable by each of Oscatello and Eliza for the shares, and the Oscatello shares respectively, is as follows. And then there's a description of what shares are going to be issued in Oscatello to the TDT and what shares are going to be issued to Silverville in Oscatello. And then these are the crucial, this, if I may respectfully say so, is the real purpose of this clause, with 1 penny credited as paying up par value and 99p credited as premium on the issue of each share, and together with the single no-par share currently held by TDT and Oscatello being the Oscatello shares. So the purpose of this clause is to make clear what part of the consideration that was coming to Oscatello and Eliza by virtue of the share transfers was to be treated as going into share capital on the one hand, and on the other hand going into share premium account. And the reason for that is because one's company accounts has to make this distinction, and for UK tax purposes there are different treatments for distributions for companies, whether they come from share capital account or from share premium account. And your lordships have heard that there have always been UK tax issues for this trust. 4.1, completion shall take place on the completion date at Investec House. So all these obligations in 3 were subject to completion taking place. And we said that clause 4.2 is critical in understanding what the mutual obligations were between the former trustees, Oscatello and Kaupthing in particular. At completion, the parties shall do the things required of them in Schedule 2, and the parties shall procure that all instruments of transfer for the transfer of shares and the Oscatello shares shall be held outside of the UK. So this is a clause which is mutual. All the parties sign up to it. And we say it's enforceable by the former trustees against Kaupthing and Oscatello. And if one then goes to Schedule 2, one sees what the obligations were in terms of exchange of documents. And that's at 571 and 572. And can I draw, so at 571, Schedule 2, completion of obligations, 1, at completion, Kaupthing shall, and then your lordships will see at 1.4, deliver to Oscatello duly executed counterparts of the Iceland loan and the Oscatello share charge. So Kaupthing was obliged to deliver the Iceland loan document, which contained the provision for it to grant the overdraft, the loan facility to Oscatello. There was also, at 1.3, your lordships will notice, a provision that Kaupthing shall procure the formal release of Robert Cengiz under his personal guarantee. And then going over the page at at paragraph 3, at completion, Oscatello shall, and TDT shall procure that Oscatello shall, deliver to Kaupthing duly executed counterparts of the Iceland loan and the Oscatello share charge. So the document contemplated again that Oscatello was obliged to enter into the Iceland loan agreement. And we say that that was a an obligation which was enforceable by the trustees of the TDT. And if one thinks about what was supposed to happen on completion, all these transactional documents were going to be exchanged. And if there wasn't an exchange, then of one document, then there wouldn't be exchange of the rest. So these obligations were mutually interdependent. Can I just go back very briefly to 554 and 555? This is dealt with what was to happen going forward. And this was 5.1 contains the undertakings by the trustees of the TDT and Eliza and Oscar Tello to Silverville and the investors. The investors, I think, were Kaupthing's subsidiary, ISIS, and New Auckland. Yes, that's right. One finds that at 549. And one of the obligations was, one sees, to to procure the business shall be properly managed in accordance with the transaction documents. And the transaction documents include the Iceland loan, as I showed you earlier. And C, to observe the provisions of the transaction documents, any agreements, and so forth.
On the wrong page.
Page 555, my
Thank you.
Sorry. So this is clause 5.1, obligations of TDT and of Oscar Tello to manage, and including the Iceland loan, and to observe the provisions of the Iceland loan, because they are transaction documents. That's all I wanted to show you, Lordships, on the framework agreement. But the point you will see that we're making is that all the obligations there were interdependent because of the concept of a completion, an exchange of documents on completion, provided for in clause 4 and under schedule 2 of the agreement. So can we then go forward, please, to 605, which is the Iceland loan agreement. And I can take this much more rapidly. This is obviously only between Kaupthing and Oscar Tello. One sees that on the front page. Then over the page at 606, one sees this is incidentally governed by the law. Proper law is the law of Iceland, but I don't think anyone suggests this. There's no evidence that the law of Iceland is different from anywhere else. So we'll have to proceed on the footing that it's to be construed in the same way as English and Guernsey documents. Loan amount, 2.1, the bank has agreed to make available to the borrower financing an amount up to 371 million in the form of an overdraft on the borrower's business account, the borrower being Oscar Tello. And then it gives a right to draw down any amount at any time after satisfaction of the conditions precedent and prior in the due, I can't read that word, provided the aggregate amount outstanding under this agreement at any time does not exceed the lower of the maximum amount, 87% of the market value of the underlying assets. 2.2, the purpose of this loan is to refinance current debt as listed in Schedule 1 to meet potential margin calls in the borrower's subsidiaries, trading accounts, and also a payment of interest in accordance with Article 3. So there are three purposes: to refinance current debt, and refinance in this context clearly means discharge and Oscar Tello take on new debt. So the idea was to discharge the existing debts of various TDT companies and of the trustees themselves. And one finds the schedule at page 615, MS 615. And Schedule 1, current, Lordships have it, current debt in the structure that will be refinanced. And we suggest this contemplates this is something that is going to happen and has to happen under the terms of this arrangement. And the debt with which we're concerned is the third one down, as your Lordships have seen, Investec Trust, Guernsey Limited, 5962, and the figure was roughly 39.4 million. Your Lordships will also see that Thorson's debt is being repaid too, and of other companies within the TD companies that were being transferred into this Oscatello structure. So the idea was to discharge the existing debt, and Oscatello would take on the new debt. So, Lord, that's the, unless your Lordship's got any questions on that, that's the contractual background. And it's on that basis that we respectfully submit that there is no scope for the imposition of restitutionary obligations on the former trustees in favour of Oscatello, given that the parties had regulated their mutual relations by these contracts. And it's our submission that there was a tripartite contract. There were many other parties, but as between the important people for the purpose of the restitution claim, that's to say the claimant Oscatello, the defendant, the former trustees, and the third party, Kaupthing, there was a tripartite contract which regulated all these matters, and that there is no scope for imposing a separate restitutionary obligation. And for this purpose, can I take your Lordships just briefly to two cases. The first is the Pan Ocean case, and it's in Authority Bundle 11134. It's MS 24221. My Lords, can I just remind your Lordships of the facts? The claimant chartered a vessel from a third party called Trident. I'm going to use the phrase third party. There was a contract between Pan Ocean and Trident, but I'm using third party to describe someone who's not a party to the action in question. And the charter provided for Pan Ocean to pay hire in advance. And there was also a specific provision in the contract for overpaid hire to be returned at once. The Trident, the third party, assigned the benefit of the receivables from the charterer to a company called Credit Corp, the defendant. Pan Ocean, the claimant, made advance payments, but then the Trident, the third party owners, withdrew the vessel from hire, and Pan Ocean treated Trident as being in repudiatory breach. Now, Pan Ocean thought that the third party Trident was not worth suing. So they sought to recover by way of a restitutionary claim the amount of their advance hire from Credit Corp, and there was no contractual relationship between Pan Ocean and Credit Corp. And your Lordship will see that the key passages are at 164 and at 166. So that's MS 24224 and then 6. And this is the speech of Lord Gough, just beginning at letter E. He says, having analysed the structure of the contracts, who the contracting parties were.
Which page again?
24224, my lord, and internal number 164. And it's letter E. All this is important. It's about halfway down the page. All this is important for present purposes because it means that as between shipowner and charterer, that's to say Trident, third party, and charterer Pan-Ocean, there is a contractual regime which legislates for the recovery of overpaid hire. It follows that as a general rule, the law of restitution has no part to play in the matter. The existence of the agreed regime renders the imposition by the law of a remedy in restitution both unnecessary and inappropriate. Of course, if the contract is proved never to have been binding, or if the contract ceases to bind, different considerations may arise, as in the case of frustration. And he said, we're not concerned with that sort of case. And H, it follows that in the present circumstances, and indeed most other similar circumstances, there's no basis for the charterer recovering overpaid hire from the shipowner in restitution on the grounds of total failure of consideration. And then there's an important passage over the page, 166 internal, MS 24226, letter D. Lord Gough said, I'm of course well aware that writers on the law of restitution have been exploring the possibility that in exceptional circumstances a plaintiff may have a claim in restitution when he has conferred a benefit on the defendant in the course of performing an obligation to a third party. And he quotes Gough and Jones and Professor Burrows. But quite apart from the fact that the existence of a remedy in restitution in such circumstances must still be regarded as a matter of debate, it's always recognized that serious difficulties arise if the law seeks to expand the law of restitution to redistribute risks for which provision has been made under an applicable contract. Moreover, it would in any event be unjust to do so in a case such as the present, where the defendant, Credit Corp, is not the mere recipient of a windfall, but is an assignee who has purchased from Trident the right to receive the contractual debt which the plaintiff, Pan-Ocean, is now seeking to recover from Credit Corp in restitution, despite the fact that the relevant contract imposes on the assignor, Trident, an obligation of repayment in the circumstances in question. And there is nothing in the assignment which even contemplates, still less imposes, any additional obligation on the assignee, Credit Corp, to repay. My lords, we respectfully rely on that passage a number of ways. If one applies the statement of principles there to the facts of this case. First, we would say that in the present case, the defendant former trustees did not receive a windfall when the Oscatello Company discharged its debt of $39 million to Kaupthing. That's because it was expressly contemplated by the contract that that is what would happen. And it was on that basis that the former trustees transferred to Oscatello their shares in the TDT companies. Secondly, the way the parties, that's to say the former trustees, Oscatello and Kaupthing, dealt with the matter involved a choice about how to allocate risk in this case. Previously, it had been the former trustees who were liable for 39 million odd to Kaupthing. This Oscatello restructuring and the framework agreement provided for Oscatello to take on all the debt under the refinancing in place of the former trustees. And in exchange, obviously, they got the transferred shares. But the arrangements specifically reallocated risk as between the parties.
It's really a question of reallocating risk. I mean, your basic case seems to be that it was contractually agreed that it would be paid off by Oscatello instead of former trustees, full stop. That's all you need.
And there's one final point, though, which is obviously relevant, and that is that there is nothing in the contractual documents that imposes an obligation on the former trustees to pay £39 million back to Oscatello. It's the absence of that obligation which is ultimately, we say, decisive.
Well, I mean, that how far does that go? If I request you to pay someone on my behalf, there's no express obligation or no obligation expressed that I will indemnify you, but it's certainly implied. So the mere absence of a contractual obligation to repay is not the end of the matter. There's got to be an intention that you should take over my debt, and there would normally be some quid pro quo. And the whole basis of your argument is that there's lots of quid pro quo, even it's not expressed as the consideration, but it is in reality one of mutual obligations which compensate each other.
But it also goes to what the expectation of the parties were. That's how they defined their intentions. So the other authority, which I should take your lordships to, English authority, is one you're probably familiar with from other cases. It's a case called MacDonald and Costello. It's in the authorities bundle 26343, and it's MS 29820. My Lords, this is a decision of the English Court of Appeal. There were originally three parties in the action. The claimant was a builder, and it entered into a contract with the third defendant, a company called Oakwood, which was owned by two individuals, the first and second defendants. And McDonald's, the builders, were to, pursuant to the contract with Oakwood, the third defendant, to construct, do construction work on the land of the first defendant and the second defendant. And the evidence was that there had been a specific decision taken between McDonald's, the claimant, and first and second defendants, that the contract should, for tax reasons, it was said, be between McDonald, the claimant, and Oakwood, the third defendant. There had been a deliberate decision not to contract with the first and the second defendants. And when the third defendant didn't pay, all three parties were sued, and the judge found that the first and second defendants were liable in unjust enrichment to because the benefits that they'd received at the expense of the claimant builders McDonald's. And the head note states the principle which one finds below, that the general rule was that restitutionary relief for unjust enrichment was not available against a defendant who had benefited from the claimant's services rendered pursuant to a contract to which that defendant was not a party, that although the first and second defendants had been enriched by the work carried out on their property by the claimants, since the claimants with full knowledge of the facts had entered into the contracts with the third defendant only, and not with the first and second defendants, the general rule applied and the restitutionary claim against them failed. And the relevant parts of the judgment of Lord Justice Etherton, with whom the other members of the court agreed, one can really pick it up at paragraph 20 at MS 29826, or internal page 250. 29826, and it's Lord Justice Etherton identified that there were 2 points of principle. We're not really concerned with the first, because it wasn't really argued fully. The second, though, was the one upon which the case is ultimately decided, at 21. The second point of principle is whether a restitutionary claim should be allowed to undermine the contract between Oakwood, the third defendant, and the claimants. That is to say, the way in which the parties chose to allocate the risks involved in their transaction. The parties arranged the transaction as one in which legally enforceable promises were made only between Oakwood and the claimants, even though the benefit of the contract was to be conferred on Mr. and Mrs. Costello. The obligation was to pay for the claimant's services and so forth, and so the risk of non-payment was contractually confined to Oakwood. If a claim was permitted directly against Mr. and Mrs. Costello, it would shatter that contractual containment. It would also alter the usual consequences of Oakwood's insolvency, which was one of the risks assumed by the claimants in contracting with Oakwood, since a direct claim against Mr. and Mrs. Costello would improve the claimant's position over Oakwood's other unsecured creditors. We can pass over 22, which dealt with the first point. 23, so this is page 29827. I'm clear, on the other hand, that the unjust enrichment claim against Mr. and Mrs. Costello, the first and second defendants, must fail because it would undermine the contractual arrangements between the parties. That is to say, the contract between the claimants and Oakwood, the third defendant, and the absence of any contract between the claimants and Mr. and Mrs. Costello. The general rule should be to uphold contractual arrangements by which parties have defined and allocated, and to that extent restricted their mutual obligations, and in so doing have similarly allocated and circumscribed the consequences of non-performance. That general rule reflects a sound legal policy which acknowledges the parties' autonomy to configure the legal relations between them and provides certainty, and so limits disputes and litigation.
And the analogy with this case would be if we were considering whether Coupting could sue the former trustees, and that might be a rather interesting question. So perhaps this case is not totally analogous.
My Lord,
I mean, it's recorded in Schedule 1 as an Investec Trust Guernsey Limited debt, so it's difficult to say that the actual agreement is an agreement to discharge the claim which Coupting had against the former trustees until at least it's actually paid off by Costello, unless and until.
My Lord, I think...
I mean, every set of transactions has to be looked at separately, and I mean, this goes to a completely different point about who bears the risk of non-payment, and obviously it's a correct decision. Nobody, I think, is likely to suggest the contrary, but it's a very long way from the present issue.
Lord, can I just take... There's a review of the authorities, including the Australian Authority of Lumbers and Pan Ocean, and the principle that Lord Justice Etherton derived from the authorities, you'll find in paragraph 30 of the, and that's the head, the one that's found in the head note. So the outcome of all the cases cited above clearly supports the general policy of refusing restitutionary relief for unjust enrichment against a defendant who has benefited from the plaintiff's services rendered pursuant to a contract to which the defendant was not a party. We'd say there is an analogy here in that the defendant, the former trustees, received, it wasn't a service, but a benefit in the form of the discharge of its debt by Oscatello, and that was carried out pursuant to a contract to which the former trustees were not a party. So that's the basis on which we cite the...
Well, I mean, the contrary argument is that actually you're focusing on the wrong contract. The contract which might be relevant is the framework agreement, which contains a request by the former trustees, effectively, that Oscatello enter into the Iceland agreement and pay off the former trustees' debt. But you interpret that contract in a different sense. So it seems to me to get back to your first point.
My Lord, I do. That's my primary case. No, I must be clear about that. That is my primary case. Yeah. It was if it were, for any reason, it was that primary case was not acceptable, that I'm highlighting this secondary point. So, my Lord, I don't think there's much more I can say about that. The one other case to which Lordships weren't taken yesterday, and I'm not proposing to take you, but if I could just mention, which is often cited in this context, is an Australian case by the High Court of Australia called Lumbers and W. Cook Builders. And that's really about the position where you have a contract between a claimant who is, in this case, was an employer under a building contract, and it was the defendant entered into a contract with S, a builder, and S, in effect, subcontracted to an associated company, which was later the claimant. And there was no knowledge on the part of the defendants who had employed the S of this arrangement. And when the subcontractors went into liquidation, they sought to recover on a quantum meruit the amounts or the value of the work that they had done in building works. And
when the subcontractors went into liquidation?
The subcontractors, Your Lordship. Yes, exactly, my Lord.
Right.
Exactly.
They sought to recover what, direct from the defendant, yes?
They did.
Yeah.
And the High Court of Australia rejected the claim in part because there was no evidence of a request, but also by the defendant work should be done. But both in the minority judgment of Justice Gleeson and the majority judgment, there was a clear statement that the parties had chosen to allocate risk in a specific way.
Can I just ask, I mean, you haven't given us the reference to it, but are you sure you don't mean when the main contractors went into liquidation, the subcontractors sought to claim? Isn't that more like the position?
No, builders had done the work. They were the claimant.
Yes, the subcontractors were the claimant.
Yes.
Yes, but who went into liquidation?
The subcontractors.
The subcontractor. Mm. Why were they seeking to? Why didn't they just sue the people they'd contracted with?
They sued both, and they
Well, that was the High Court of Australia said it was all very murky,
all right,
and no one really understood what had happened between the main contractor and the subcontractor.
I see.
You have a page number.
I'm sorry, it's 23554.
554.
It's in the authorities bundle 10 at 110. I'm not proposing to go to it. In the English academic writers regard it as a slightly controversial judgment, not decision. They regard the decision as entirely correct, but there are some rather disparaging statements there about so-called top-down reasoning to impose restitutionary obligations. And
with the members of the court, well, it's a forthright court.
Gummo, I think.
There's Chief Justice Gleeson and Justices Gummo, Hayne, Crennan, and the present Chief Justice. Yeah. I suspect it was Justice Gummo.
I think he is responsible for the judgment which has caused some consternation amongst the English academics.
Usually expresses himself powerfully.
He does. So that really is that's our primary case. That this is not if one analyses the contracts in the way that we have, and this is really a case of a tripartite contract, and there is no scope for a restitutionary obligation to be imposed in such circumstances. The law of contract has to prevail because the parties have chosen to regulate their obligations in that way.
Yesterday I asked Mr. McQuater whether it was the law that if a contract contained two obligations by, let's say, an AB contract by B, and one of them was described to be the consideration for A's obligation, that meant that the other one, the other obligation, couldn't in any way be regarded as part of the consideration or quid pro quo.
I'm not aware of any authority which would support the proposition that a statement that something is consideration for O's obligation in this case could be treated as a matter of construction, as something which was intended to mean that there were no other enforceable obligations against O. Because the basis of the argument, I mean, to take your first point, Lord, I'm not aware of any authority on that.
I raise it only because the heart of your case is that, notwithstanding, I forget which clause it was that identifies the consideration, the taking of trustees' debt out thing off their shoulders was part of the quid pro quo for Oscar Tello getting all the shares.
My lord, yes, that's the heart of our case, yes. And what we'd say about that is that if one reads the contract as a whole, the position was that it is evident that there are a number of mutual obligations as between all the parties, and one finds that in particular in clause 4.
The change of position argument, I don't know, I mean, you're fairly short of time, but the change of position argument doesn't add anything, does it? It's simply the same point put in different language, because the change of position is said to be performing the rest of the agreement. If the rest of the agreement was to the effect you allege, then that ends a claim. If it wasn't, then it's irrelevant. It's not, isn't that position? I mean, how can you, unless it is actually implicitly contemplated or agreed that this will be the end of the matter, that the debt will be discharged without recourse, you can't succeed by looking at the terms of the agreement in terms of change of position. They wouldn't be entitled to rely on the rest of performance of the rest of the agreement unless that was its substantive effect.
Well, I think that what I'm dealing with an argument that based on BVI Company's argument that there was no connection between the transfer of the shares and
Yes, but I mean, if there was a connection, and if the connection was, we'll transfer the shares, and that's you'll pay the debt, and that's the end of it, and no recourse, fine. But if the agreement to transfer the shares is separate from any such understanding, in other words, it left open recourse, then it can't be a relevant change of position. By definition, by terms of agreement.
A causal link between the
Yes, but merely performing the terms of other terms of an agreement, which itself contemplates recourse, would not deprive the recourse provision of effect.
Well, if the agreement had expressly provided that Oscatello was entitled to 39.4 million from Kaupthing, then of course that would be, again, you're right.
And if it impliedly provides that, notwithstanding the other things which are going to be given, like the shares, then the giving of the shares can't have any effect in removing the implied recourse. The whole question is whether the agreement as a whole does contemplate some recourse in respect to the payment off of the Oscatello loan or not, isn't it?
Yes, well, obviously, if there were an express term or an implied term, as your lordship says. Yes, I
just got to stand back.
Yeah.
And I mean, I don't know whether you have finished the first 4 points now.
Well, I haven't dealt with the third point, which is, of course, about how free acceptance would operate if.
But if there's no expectation because the agreement implicitly excludes recourse, then free acceptance it must be irrelevant.
Well, my lord, that would be our
Yes.
that is our case.
Right.
But perhaps just and I'm happy to deal with it on the basis of what we've put in the papers. Can I say this, that putting it as briefly as I can, obviously if free acceptance were relevant, the key element is what were the expectation of the parties, and we say one has to look at the evidence very carefully in this regard, and that there's no evidence of what the expectations were on the 19th of December 2007, when the framework agreement and the Iceland loan, the overdraft agreement, were executed. So that the basis on which my learned friend for Oscatello has sought to persuade you that there was an expectation is all based on events after the contracts were entered into. He relied in particular on the funds flow document and the fact that after the transaction documents are executed, and presumably after completion, then monies flowed. And I think it was on the 21st of December. We say that that all occurred by way of performance of the obligations in the contract. And one can't rely on, one can't create an unjust enrichment claim out of the performance of contractual obligations. And the other matter that my learned friend relied on was the way in which, in 2008, the trustees, administrators, sought to account for what had happened and to rationalize it. And there seems to have been an understanding or an expectation that somehow it could be treated in the same way as previous arrangements where funds flowed up from a TDT company or a TFT company to the trustee and then back down again. But the distinction was that here the funds were going out to a third party, Kaupthing. And so whatever may have been the practice in relation to different sorts of transactions, that expectation couldn't have been relevant. And moreover, and I'm not going to go through the evidence, but you'll find it in our written case. It's at 14209 to 14212. That's paragraphs. I can pick it up about 238 to 242. Sorry, is it? Yes, 242 of our written case deals with the factual position. But I don't think I need to go through all that today. I've summarised all the matters on which we rely. So, subject to, unless your lordships want me to develop anything that's said in those passages further, you've got our case there. The final point relates to Article 32, and I don't think I can add much more than what I've said already, which is that if it were found that Oscatello has a claim in unjust enrichment against the former trustees as a result of the discharge of the 39 million debt, then we would respectfully suggest that that is a claim which falls within the language of Article 32(1)(a) as a matter it arises out of a transaction or matter affecting the trust, where the trustee was a party and Oscatello was a knowing third party. And there was some debate yesterday about the sorts of circumstances in which transaction or matter affecting the trust, or where there were parties to any transaction or matter affecting the trust, could cover certain types of claims. But we would say where you have this sort of situation, on the facts, there were transactions and matters to which they were all parties, that's to say Oscatello, Gupthing, and the TDT trustees. And on that basis, we say whatever the precise limits of the words transaction or matter are, we fall squarely within them.
So you're not proposing to offer a definition of matter?
I think
the problem is
many hues have tried. Sorry, that was.
Well, I can quite see why you submit that you don't need to do it for the particular purpose of your present submission. The problem is that it also affects the coherence of different views that might be taken about the effect of Article 32 as a whole.
Sorry for that.
Which is why it would be useful to know what people did say. Matter meant. I didn't get very far with Mr. McQuaid on this yesterday. Are you also going to duck it?
It may be, because it is intrinsically difficult to see the precise boundaries.
Well, that's why I'm asking the question.
My lord, I know. As my old friend pointed out, you have to be a party to the matter, and you have to have two parties. And so it involves some element of interaction between the trustee and the knowing third party. I would respectfully suggest there might be cases which go beyond simply contract or failed contracts, for example, void contracts or quantum merit claims, that kind of thing, which would be obviously within sort of framework of transaction. There might be some tortious cases, and I'm not thinking of the case where the trustee strikes some third party over the head, but there are cases where the trustee's agents are involved carrying out activity within the scope of their authority. And it's with a third party who knows that the third party knows that the agent is for the trustee.
Many tort liabilities depend for their existence on a pre-existing relationship between the parties. Most tortious liabilities that give rise to purely financial loss could probably be put in that category.
I was thinking of Hedley, Byrne and Heller
as
one sort of case which might come within matter. And obviously it would be curious if it didn't, if one thinks of a case like Henderson and Merritt, where you have the overlap of contract and tort claims. And it would be extraordinary if because the claim is brought in tort for some reason, but it could have been brought in contract, or there might be different limitation issues, that one should be within the scope of protection and the other shouldn't. And that's why, right at the outset when I was talking about Article 32, I did suggest there were cases where it could extend to tort. And that would again be consistent with the American Uniform Trust Code, which does contemplate that trustees may not be personally liable where for tort, the Uniform Trust Code contemplates that they haven't done anything wrong, but one can see that there might be cases where they're vicariously liable through an agent. So, my lords, inevitably, I focus very much on my client's position, and that's why I probably haven't done as well as I could in response to your lordship's question. But that's where I got to in analysing what matter might mean.
Thank you.
And the totality of all claims, I mean, if there are other claims against the trustee as trustee by people who know that the trustee was acting as trustee, they only have one pot. Is that the position? When it says, and shall extend only to the trust property, or?
Yes, my lord. Yes,
that's your case. Yeah.
Yes, if there are two knowing third parties who've been involved in transactions or matters affecting the trust with the trustee, then
not a sort of repeated cap per claim.
No. Is there anything else I can help with?
Thank you very much indeed. Yes, Lord Goldsmith.
My Lords, a lot of what Mr. Taub has said I'm going to gratefully adopt. Our principal point in relation to this is that actually the Court of Appeal got it right in a paragraph which hasn't really been looked at very hard and has perhaps not been fully understood. There are actually two paragraphs in the Court of Appeal's judgment that maybe we're just looking at this stage. That's to be found at page 78 of the first court bundle, which is also the MS number. And there are two paragraphs which, although shortly stated, actually show the position, paragraph 176 and paragraph 178, both of which I think were criticised by Mr. McQuater, my learned friend. But although shortly stated, they do explain the position. The first in 178 is the sentence which says, it would make no sense that immediately after the arrangements of December 2007, the assets of the TDT, through the ultimate shareholding in Oscatello, would embrace the liability to Coupting, while at the same time the TDT would be immediately liable to Oscatello in restitution for the cost of the discharge. Now, although shortly stated, that actually makes the point, of course, the principal point that my learned friend Mr. Taub has made, that the payment, the discharge of the Oscatello debt was pursuant to an agreed regime, to use the language of Lord Gough in Pan Ocean. But it also shows the reality of what was taking place. And I want to try and tie some of the strands together, and that will also help with the other paragraph which has been touched on in the Court of Appeal's judgment, which explains their thinking, which is paragraph 178. Paragraph 178 contrasts what was happening on the Oscatello restructuring with what had happened when the TDT took over the assets and liabilities from the TFT. The point being made was, well, that when that was done, there was a novation. That's how that transaction took place. And this was not done in this case. This wasn't a novation. But of course, what we say is that although, of course, it wasn't a novation, it had exactly the same effect, namely that what was happening was a liability to Coupting by the TDT was discharged and replaced with another liability to Coupting in the same amount, which was through the overdraft facility. So what I wanted to do was just to try to make that good by pulling together a little bit the strands, the factual strands, first of all. And I don't want to take your lordships back through clauses in the agreements that you've already been taken to in some cases twice, but I do want to just touch on what they are. And obviously, your lordships have from the framework agreement the essence of the Oscatello restructuring, but the important points, and your lordship's seen it now, what was happening was that there were debts which up to that moment were due to Coupting. Those were all being discharged. My Lord Briggs asked about the other payments, for example. There's a list of payments that were being discharged, as I understand it. Those were the rest of the indebtedness to Coupting. And what was then happening was there was a replacement of that. My Lord Mance referred yesterday to a refinancing, and that's precisely what this was. And it was a refinancing by way of now having the overdraft facility, known as the Iceland loan, to Oscatello, and the two PPLs, the two profit participation loans, I think either 150 each or 150 together. So one can look at the numbers and see the relationship between them, 300 or so on the overdraft facility, 150 on the two PPLs, and that's how the indebtedness to Coupting was being discharged. Now, although your lordships have seen two of the agreements in actually the suite of agreements that gave rise to the Oscatello restructuring, there are others in the bundle, just one that may be worth looking at, which is the share charge agreement. Now, your lordships had seen in the framework agreement that what was going to happen was that a number of companies were going to be transferred into the Oscatello structure, 11 companies, as my learned friend rightly said. And a charge was to be given over the shares in those companies. And one sees that in the share charge agreement, which is at 617 in the MS numbering, which is in core bundle 2, I think also at page 617, because the numbers match at least at this point. So 617 is where one sees the share charge, and there's a definition which we'll need in one moment of secured obligations, which appears at page 618. And the secured obligations are all present and future obligations owed by the borrower to the lender under the facility agreement. And the facility agreement is defined on the preceding page, bottom of the preceding page. It is what we now know as the Iceland loan, or the overdraft facility for Oscatello. And paragraph 2.2 provides that the recourse of the bank, i.e. Coupting, against the chargeor, i.e. Oscatello, in respect of the secured obligations, i.e. all these borrowings under the Iceland loan, is limited to the rights of enforcement and recovery against the mortgage securities charged under this charge, and accordingly the bank agrees that the total amount recoverable against the charger under this charge shall be limited to the proceeds received by the bank realising the mortgage securities. So what one sees there is the non-recourse element that I mentioned to your lordships, I think, a day or two ago. So this is the overall structure of the arrangement, which is a non-recourse refinancing. It's true, one element of that is also that Mr. Robert Cengiz's guarantee is being released. But importantly, a number of companies are being put into a structure. They are being provided as the security, and a new facility in three parts, the two PPLs and the overdraft facility, i.e. the Iceland loan, are being provided. Now, the important point there is obviously these are all part of a single, I'd call it agreed regime because that's Lord Gough's words in Pan Ocean, but it's certainly it's a suite of interconnected agreements, as your lordships have seen. And there are a number of elements in the agreements themselves which show that they're interconnected. And I think they've been referred to by my learned friend. I'll just enumerate them. Plainly, the framework agreement refers specifically to the Iceland loan in a number of places. Execution, entering into the Iceland loan, is a condition of the framework agreement. It's one of the completion obligations. My learned friend, no doubt technically accurate, refers to completion as requiring the exchange of documents, but of course the important part is one of the completion obligations was to enter into the Iceland loan. And just to meet, if I may, en route, a point my Lord Briggs has raised twice, could I just direct attention to one clause which is to be found at page 546 of Core Volume 2, MS, also 546, which is on the question of the meaning of consideration, or what the effect of consideration is, just to draw attention to the fact that not only does this agreement contain a number of references to mutual promises, for example, at page 545, recital B starts by talking in total terms to the terms and conditions of this agreement, but it, what? No, recital B. But then before the interpretation clause, this appears, in consideration of the mutual promises and undertakings herein, the parties agree as follows. And so it respectfully seems to us that, and not surprisingly, all of this is the consideration for all the obligations that are undertaken. Now, it's right that when one gets to clause 3.2, this was the provision which the learned Lieutenant Bailiff founded his decision on, the reference to the consideration payable by Oscatello and Eliza, and then referring particularly to the issue of shares. It would not surprise me if there's some particular, whether fiscal or structural reason why that language is used. But what I do say, and this is all that really matters, is it's clear that all of this is in consideration of all of it. And that makes sense because what is taking place is a suite of indebtedness is being removed and a new suite of indebtedness is being put in place. Part of the removal of the suite of indebtedness is to pay off the what we now think of as the Oscatello loan, that it wasn't Oscatello's at the time. It's to pay off the 39 million. I don't, my Lord Briggs asked the question, well, why isn't there a claim for restitution in respect of the other loans which were paid off? And I don't know what the answer to that is, because they seem to be, to me, and I'm obviously missing something, in pari materia. There seems to be exactly the same issue in relation to them. They're not, I think the foundation of my own friend's case is that they were requested to be paid. I also don't see that. They weren't requested to be paid, they were required to be paid. And that makes all the difference in our submission if it is, well, on any view of restitution, whether free acceptance is a separate head or not. When we see, and again, my lords have seen it, that this particular loan is one of the requirements in order to complete the transaction, loan 5962. We see that in Schedule 1, core, page 615, as your lordships have seen. And your lordships have also seen in the overdraft facility that that's one of the loans that has to be paid off with the money which is being advanced under the Iceland loan. I'll just make this one other reference. The funds flow document your lordships saw, your lordships will recall that was required to be, that included making the payment in relation to the 39 million or 36 million, the same number. That's to be found at Core 1, page 647. I think that must be Core 2, but in any event, 647 in the MS number. And that was to give effect to the agreement that the money being advanced would be used inter alia to pay off the loan, loan which has the number that we now recognise as then giving rise to the Oscatello claim. So the fund flow was to give effect to the contractual arrangements, including the 39 million and including the other payments to discharge the existing indebtedness. And as Mr. Taub rightly says, what we don't see in any of these arrangements is any obligation on Oscatello then to repay the 39, Oscatello, the former trustee, I apologise, the former trustee to pay the 39 million after it has paid that money in order to discharge the debt. And of course not, because the whole point of the arrangement is to get rid of the original obligation, substitute a new obligation, and then that obligation is enforceable under the terms of the Iceland loan.
We're going round the same point of
Well,
construction of what the...
Well, we are as construction, my lord, I apologise, we are of construction, and that's why I'm not spending long on it, yeah. But also to understand what the Court of Appeal was saying and to join the dots up, because they were actually saying, you know, it makes no sense that having as part of this refinancing arrangement paid off 39 million, the next day they're obliged to pay it again. That's essentially what it amounts to.
Yes, yeah, that's because of the underlying idea to move everything down to Oscatello.
Yes, yes. And the other way to look at this is the other paragraph in the Court of Appeal's judgment, which is at again at MS page 78.
Right, 178.
Which is in the Court of Appeal's August judgment, at paragraph 178 on page 78. I'm not going to read it aloud, but your lordships have it, and perhaps could just glance through it again.
Yeah.
What they were essentially saying was, no, this wasn't an novation quite as the TFT to TDT novation, but it has the same effect,
yeah.
Because a new debtor is being put in place. And that being the case, there's absolutely no room for any restitution remedy. Now, that may be either precisely what my learned friend has said or another way of saying it, but I wanted to try to just show how this fits into the overall structure of the commercial arrangements. I mean, we, for example, are criticised by my learned friend for at one point saying, well, if you're looking at enrichment, there isn't actually enrichment, because if you look at the Oscatello, if you look at the TDT group, as it were, TDT owning Oscatello, it's not actually better off as a result of this, because it has the obligation still under the overdraft agreement, under the Iceland loan, and it has paid out 39, and if it pays out another 39, it's worse off, not better off. So there's no enrichment there, but it's just another way of looking at the same point. My Lords, on the law, your Lordships have our written case, detailed submissions on Guernsey law, which your Lordships are not now troubled with. On free acceptance, I don't really want to say anything adding to this, unless your Lordships, which I rather apprehend your Lordships weren't minded to, take this as an opportunity to give an authoritative judgment, which would no doubt be greatly welcomed, but on authoritative judgment on free acceptance. But this doesn't look respectfully to me as if it's going to be the sort of case that's going to happen in, that your Lordships want to take that opportunity, but that's for your Lordships to say. So I wasn't going to say anything. Well, I'm not sure I should take that as an encouragement now to go into the detail of what we say about that. I'm going to restrict myself without more encouragement to saying that that we set out in our case our observations on the existence of some separate doctrine of free acceptance. But if such a doctrine exists, it does depend upon the demonstration of the expectation and the... I
mean, if it's been contractually agreed that someone else will pay off your debt, and that would be the end of the matter, naturally you're delighted freely to accept that, but it means nothing in terms of law,
Yes.
free acceptance.
Well, I think I'm in slightly choppy waters at the moment, having this. But I don't think there's anything, unless your Lordships want me to, which is really what I was trying to say, I didn't really want to say anything more about the law on that, because it's the facts we would respectfully submit that answer the question why the Court of Appeal were right to say that there wasn't a restitution claim here, and the learned judge was, Lieutenant Bailiff was wrong to be mesmerised by the clause referring to consideration with a small c, as if that answered the issue.
I think you're definitely about to earn the congratulations that
Well,
were wrongly given earlier.
Happy to accept them, my lord.
Well, thank you very much indeed, Lord Guilford. Yes, Mr. McQuater.
Yes.
Thank you. Sorry. I do apologise, man. I was just... rearranging. I can be relatively brief. Your Lordship's heard from me at some length yesterday. A number of points. Lord Briggs asked me yesterday about how the other payments made to Oscatello discharging loan liabilities set out in the funds flow were treated. My Lord, the answer to that question is that Mrs. Bleasdale treated those payments as giving rise to loan obligations to Oscatello also. And one sees that on the record at a memo that she wrote to account for these transactions at MS 1350. And one sees there a memo of Lydia Peck, 7th of January 2008. So it's obviously relatively soon after the framework agreement was entered into. So it's a short time thereafter. And this is a memoranda from her, as she explains in her witness statement, as to how she thought the transaction should be accounted for. And the relevant passage is at the foot of 1352, where one sees under item 2 the treatment of these various payments. The discharge of the former trustee's liability to Couchthink is there described as an interest-free loan to the TDT. That's the 39 million. And the 5 entries at the bottom are interest-free loans to other trust companies. So the answer is that those were accounted for as loan obligations to Oscatello, as she attempted to account for the...
And this is
discharge.
applying her usual standard practice, that if you see money moving from A to B, there must be a debt back from B to A.
Well, I would suggest that...
It must always be a loan.
Well, I would suggest that she did give the matter some thought, my lord, because there is a distinction drawn here in that paragraph between the loans to, she accounts for the monies advanced to discharge Oscatello company loans as loans to those companies. But there's the third-party loan, which is the ISIS, the third-party liability to ISIS. She says treatment to TBC. So if there's an external party, is unclear or unsure and wants confirmation of how to treat that. So she is giving the matter, I would suggest, at least some thought. So it isn't just a question of repeating a practice without consideration of what she was doing. And I would suggest that, so there is sense to this. And of course, the reason why Oscatello hasn't pursued those other companies for those debts is, of course, they're all insolvent. Now, my lords, moving to a point that Mr. Taub raised this morning on Clause 3.2a, the consideration clause of the framework agreement. Your Lordships have heard me on the framework agreement. I'm not going to reiterate our case on that, but Mr. Taub sought to explain it as a tax issue, effectively. He said that the purpose of the clause was to identify the consideration paid by Oscatello for the shares for tax purposes, by which I took him to mean one or more of capital gains tax or stamp duty purposes. Now, if for tax purposes this is the consideration being identified, if there is some other undisclosed consideration payable for the shares or paid for the shares, then the tax authorities would be given wrong information. You can't have one story about what the consideration is for tax purposes, but another story for another purpose. The consideration is what it is. And in our submission, you can't, either the discharge was part of the consideration or it wasn't part of the consideration. It's not a question of picking and choosing. And in our submission, it's not added to by the reference made by my friend Lord Goldsmith this morning at Core 546 to that very general recital of mutual obligations, because that must give way to the more detailed provisions of 3.2a subsequently in the agreement. So, and your Lordships wouldn't possibly countenance that this might be some kind of tax dodge as to, in terms of stating the consideration for tax purposes. So my simple point is the discharge either is or isn't part of the consideration for the shares. My Lords, moving, if I may, to my friend Mr. Taub's consideration of the authorities and the authorities on contracts, I would suggest when looking at MacDonald and those cases, where one gets to is the relevance of the liability Oscatello entered into to Kaupthink to discharge the debt, is that what our case comes down to is what you spell out of these agreements is that there was effectively a request by the former trustees to Oscatello to undertake that obligation to Kaupthink. And so far as that's concerned, there is, for your Lordship's reference, in the Lee and Dixon case I went to yesterday, at 23449, there is a reference specifically by the Court of Appeal in that case to undertaking an obligation at someone's request to do something. So if the proper construction of the request, as it is in our submission, is that Oscatello undertook that obligation at the request of the former trustees, you get to the same place. There's another case called Owen and Tate that we have brought copies of in I think we circulated this sometime earlier, a few days ago, so my friends have seen this additional authority. But the point about Owen and Tate, Court of Appeal 1976, I don't know if your Lordships have it to hand, but I'll make sure.
Was it just as a loose?
No, it was in a little bound volume like this. Hodge has it to hand. It's a Court of Appeal case in 1976.
I've got it loose.
Where, my Lords, I'll take this as briefly as I can, but it's in the same vein. This was a case where the claimant, without consulting the defendant, deposited very generously a sum of money with the defendant's creditor bank as security for the defendant's loan. And the defendant discovered the existence of the security and was at that point very happy to say, well, take the repayment of the debt from the security. But at that point, of course, the defendant was obliged to let the security be taken. And the claimant didn't recover because the deposit had originally been made voluntarily without a request or knowledge of the defendant. But Lord Justice Scarman, at 407, just beside letter E, said this: I need not at this stage do more than just refer to those two cases, in each of which one sees the point being considered whether in the circumstances of the case the law could imply a request, consent, or some sort of authority for the payment made. So he suggests that had there been a request, there would have been recovery in that case. And by the time, of course, that the deposit was taken, the claimant was obliged to let it be taken. It had entered into, in parallel with the Couchthink overdraft, an obligation to do so. My Lords, your Lordships asked about, and my friend referred to the Lumbers case, the Australian High Court, which is a very authoritative tribunal with, well, a very authoritative and impressive tribunal. It's at, in Bundle 10 at Divider 110, if I could just go there very briefly.
MS?
MS 23581. And, my Lords, I was going to draw your Lordship's attention to what the court said at paragraph 89. That's 23581 of that decision, where the court said this. I think it was the judgment of the court, delivered by Chief Justice Gleeson. Oh, sorry, this is Justice Gummow. And he says this at 89: it will be noted that the second of the matters identified was a making of implied request by the Lumbers to builders to do the work and to pay money. Once it should be pointed out that if builders did whatever work it did and paid whatever money it paid at the Lumbers' request, builders' claim for a reasonable price for the work and for the money it paid would fall neatly within long-established principles. It would matter not at all whether the request was made expressly or its making was to be implied from the actions of the parties and the circumstances of the case. And he cites authority on that and says builders would have an action for work and labour done or money paid for and at the request of the Lumbers. So the exposing yourself or taking on a liability, we say, would equally, at someone's request, would equally satisfy in our submission. Yes, and we say that even if my friends are right about the analysis of the framework agreement, there was at minimum, there was a request to Oscatella to enter into the framework agreement. And perhaps I should say in closing that this isn't, one could analyse this case as being a case where the former trustees adopted the benefit of this payment on their debt being discharged. It's agreed that their debt was discharged, and their pleaded case, which is at MS 673, paragraph 678, MS 678, paragraphs 30 to 31, is that there was a discharge of the debt. Well, sorry, I beg your pardon, that pleading says it's a loan, which we say is a clear adoption of the payment. My Lords, unless I could assist you further.
Well, let me just, I'm afraid my thing has gone down. I can't turn to that page.
Yes, our case on paragraphs 30 to 31 is, this is the former trustees pleading, which is signed on their behalf. These must be taken to have adopted what is in those paragraphs.
So what, this comes from what? This is the case.
This is the former trustees' amended application. They're pleading in the Guernsey proceedings below. So they effectively adopted it as a loan. And in fact, I think from recollection, the former trustee's case below in front of the Court of Appeal was that there was a valid loan. I think you see that from the Court of Appeal's judgment. From recollection, I think 130, paragraph 137, but I may, I'll just check. It's, yes, it's on core page 73. The Court of Appeal below, paragraph 137, you see a recital of what the former trustee's case was before the Court of Appeal, and that was that this money was a loan.
Sorry, MS 70,
MS,
73, paragraph 137,
yes,
which is,
that's the former trustee's case below in front of the Court of Appeal being recited.
sorry, what does 137 read? How does it, what's it start
For
with?
the former trustees.
Yes, so
Advocate Wessels.
I see. The contentions. So, and what is the status then of this, paragraphs 30 and 31?
That's the former trustee's pleading in the case,
Has it been withdrawn?
not as far as I'm aware, no.
Well, you're making the point that it seems to be completely contrary to the argument now being advanced.
Well, quite, and it also amounts to effectively them adopting the transaction.
Right.
As far as that's relevant to the unjust enrichment claim. But, and it is a contrary case. It's because they...
Well, they now say the exact opposite.
Yes, they're now saying it wasn't a loan.
Well, we'll have to hear what explanation there is of that, I think, because I'm not sure we've had one.
Would that pleading in any event bar the present trustees from taking the point?
Oh, well, that pleading can't affect the... I wouldn't have thought...
So the point's before us anyway.
The point is before, but
Yes.
I think the point is that it's the former trustees who were having their debts discharged who saw it as a loan. I think that's the relevance of it. And if they adopt it, we would say that whether it's adopted by the present trustees is not relevant.
So you say it's adopted for good or ill on behalf of... Yes.
Yes, it also means that some of the submissions your lordship showed this morning sound a little bit hollow, but there we are, that's more of a forensic point.
Can you just repeat for me the page number of the relevant pleading? I'm afraid I
Yes, my lord.
gave it first time.
It's MS 678.
678. Thank you.
But you say adopted not just on their own behalves, but adopted on behalf of the trust.
Well, indeed.
Right.
Well, yes. Well, in our case, they're personally liable, of course. But, yes.
Right. Yes.
And it discharged a personal liability to Countbank of the former trustees. And no one's disputed that former trustees were personally liable to Countbank on that debt that got discharged.
So what was the nature of the argument then below on this issue? In other words, how was the restitution claim resisted? If or how was a claim resisted? I suppose, was any claim ever mounted on the basis of a loan? It presumably wasn't.
I think the former trustees' position in the Court of Appeal, and I'm sure Mr. Towe can speak to this, is that no restitution because it was a loan.
But your loan claim failed.
The loan claim failed. As a result. Yeah, so we've fallen into some abyss.
So if you haven't got a loan, how does if that's conclusively established by the courts already, how does the pleading, which may now be departed from, have any effect at all?
Yes, yes, we would say that it amounts to an adoption of the benefit of the transaction for the purposes of restitution.
Well, on a wrong basis completely. Yeah.
Well, it would certainly put in a contradictory basis below by the former trustees. Your lordships can see at 137.
Incidentally, I mean, bearing in mind it's admitted as a loan, just remind me as to why the loan claim failed.
Lack of authority was found below.
Although their case was, the lack of authority was something that could be run by the former trust.
Well, they were saying there was a loan. In fact, they were saying Mrs. Bleasdale had authority. The former trustees. They were saying she had authority, but that
This isn't a pleading about the effect of the framework agreement at all. It's a pleading about what happened on the 21st of December, as I think I understand.
Well, they're still adopting the transaction and the benefit of the transaction, and saying that it was properly analysed, it was a loan. So and if they think it was a loan, they obviously think there was an expectation of repayment, reimbursement. I think, unless your lordships have further questions, anything else would be repetitious, perhaps.
But the lack of authority point was taken by who then?
The present trustee took the lack of authority.
Yes, I see. And that succeeded. So, yeah. Right, well, I think I've got the position.
Obliged, my lord.
Right. Yes, and is there anything that either you, Lord Goldsmith, or Mr. Tower wish to say on this last point, which comes slightly out of the blue?
Would your lordships like an explanation of what happened, or,
well, if
or are you confident you know what the position is, my lord?
Well, it's quite difficult standing on one's head, so perhaps we'll have an explanation.
Yes. I don't know which I will do. Offer an explanation.
I think
on my head.
I think there does seem to be an element of standing on your head on your side, but one understands the loan claim disappeared for reasons which weren't advanced by your side. But
your lordship will recall that the application in Guernsey was by the trustees for directions as to what the position was, because there were competing arguments. The BVI companies claimed there were debts. The beneficiaries, Mr. Cengiz and his replacement trustees, R&H, said, no, there are no liabilities. So that issue had to be determined. And the trustees, the former trustees, whom I represent, had, in their accounting, treated this sum of 39 million as a loan through Mrs. Bleasdale. And so that was the basis on which the matter was pleaded, as I understand it. At the trial before the Lieutenant Bailiff, the question of the authority of Mrs. Bleasdale was in issue for a variety of reasons, not least in connection with what are called the book entries. And the whole question of who could bind the companies and the trustees in relation to these matters was considered at considerable length at the trial. And the conclusion the learned judge reached was that it required board authority to do these things. And so whatever a trust administrator might have thought the position was, he said she didn't have authority.
I mean, it's very like, it's a microcosm of the big argument about the book entries later in 2008, as I understand it.
I'm sorry, I missed. Yes, sorry, my lord. I didn't quite get. I think I've. Yes. So, and then the learned Lieutenant Bailiff also decided, again, perhaps like the surprise of former trustees, but that's so be it, that there was a restitution obligation, not a loan obligation. And so there were then multiple appeals to the Court of Appeal on all these issues. And the Court of Appeal confirmed the Lieutenant Bailiff's finding that there was no loan because of the lack of authority. And that was decided into parties. And then they also dealt with the restitutionary claim by Oscatello and rejected that. but for different reasons, as you've seen. So whilst you may think it's a sort of feat of heroic gymnastics on my part, if it was really taken out of our hands by the way the court dealt with the matter.
Yes, but I mean, it is slightly odd that they were advancing the proposition that there was a liability, and if there was such a liability, it was one which must, on your present submissions, have been accepted completely contrary to the effect of the framework agreement.
My lord, yes. I mean, I think it was because this. I stress the case before at all stages has been a three-hander, and the question is ultimately what is the true analysis of what has happened, and we've been educated.
Well, whether that's the function of litigation is an interesting question. But thank you very much. Yes, Lord Goldsmith.
Well, my lord, I wasn't aware until my learned friend said it that there might be a suggestion, as against my clients, that because of some adoption of this loan, that answered the question that we've been considering. As I understand what's happened below, the argument was raised that the payment by the former trustees was a loan. That was rejected. It was rejected by the Lieutenant Bailiff, and there was no appeal against that. So the finding stands that there wasn't in fact a loan.
There was an appeal.
What?
There was an appeal.
Okay, I'm sorry, I'm corrected. There was an appeal on the loan in the Court of Appeal, but there isn't now. Perhaps at least that. So it's not a live issue whether there was. As your lordships are very well aware, there is no common interest, as it were, between the former trustees and the present trustees on a number of issues, and the difference being that the former trustees have an interest in trying to get indemnities in relation to payments that had been made, which have been resisted by the present trustees, and that's substance of what we were arguing about. So I'm not aware, but slightly taken by surprise because I hadn't seen that point being raised in my learned friend's case against us here, that it was going to be suggested that the answer to the case was actually, why are we spending any time talking about restitution? Because in fact, both the former trustee and on behalf of the present trustee are bound by a concession that was made in a pleading. Interesting.
Yes.
But as far as we're concerned, at least on this, I don't think we've been doing any gymnastics other than to say no claim restitution or by way of loan in relation to this payment, and it would be, as my lord said, completely contrary and inconsistent to the framework agreement and the restructuring arrangements that were being made at that stage for that payment to be, as it were, visited upon the present trustee, and therefore
might it not also be said, Lord Goldsmith, that the concession was one of legal analysis, which has been overruled by the court because Mrs. Bleasdale didn't have authority to create the loan. If she didn't have authority to create the loan, where can we hold she had authority to adopt anything?
My lord, yes, I respectfully adopt that. As my lord, yes, indeed, and as my lord Briggs said, I mean, this is a microcosm of a bigger dispute, which actually figures in other aspects of this appeal. But I'm not sure I can say anything more about it. I mean, I hope I've demonstrated why, whether or not there's any difficulty or embarrassment on the part of the former trustees, this can't be visited against the present trustees, and the decision as to whether there was a loan has gone, and that is not a subject of the appeal, and the only question outstanding is there a claim in restitution?
Greater, is there anything more you want to say?
Well, just that
Live.
it's not our case that the pleading creates the loan or anything of that nature. The pleading is not just Mrs. Bleasdale's pleading. The pleading is the former trustee's pleading, which is saying this was a loan and there was an obligation to repay it, which in our submission has consequences, which is, I'll just be repeating myself, because that they adopted the benefit and that there was obviously an expectation of repayment. and on the basis of authorities we've cited, my lord.
But you haven't in fact appealed the loan point to this.
We haven't appealed that on the basis of a loan, my lord.
No.
No.
Right. So, we're ahead of schedule. I think you're going to take the opportunity, am I right, to address us on the subject matter of the email which was sent by the registrar yesterday? Who would wish to address us initially on that?
Would it be sensible for me to start on that, given...
Well, as long as you're agreed between yourselves.
Well, I haven't agreed, but I'll look to my learned friends and see whether they want to take the honour of going first.
As long as you don't use all the time.
Right,
Never
yes.
mind about
No
that.
filibustering.
My lords, subject to one proviso,
Yes, it probably is logical for you to begin, yeah.
my lord, I'm
Yes.
obliged. Subject to one proviso, having discussed this, our view is that if your lordships were willing to undertake the analysis which is referred to in the registrar's email, if your lordships were willing to undertake that analysis, then we would be very pleased that your lordships would do that rather than go through a remission, because that would involve more time in a case which has already taken a long time to get to this point. Your lordships are seized of a lot of the issues at this stage, and my clients would be happy for your lordships to decide it if you would. We recognise that whether your lordships do take that course or determine to remit it is obviously a matter for your lordships. So I'm just responding to what our preference would be if that were a matter that carried weight with your lordship.
Well, then we would need to know on the basis of what evidence.
Yes.
And you would have to do what the last paragraph or last substantive paragraph of the email said, namely identify with clarity.
Yes. My lord, what we've attempted to do overnight is we've attempted to identify what we think the material would be that we would invite the board to consider for that purpose. It's a tiny bit provisional because it's been done overnight, but it may at least give an indication of what we think at first blush would be necessary. I'm happy to hand that up. My learned friends haven't seen it yet, I have to say, because...
well, I think you should at least show it to them over the adjournment.
I'm happy to do that, and I can make the point as well that I'm not sure that the list actually identifies any of the transcripts of evidence. Your lordships have seen some reference to them already, and I should make the point, I think some of that, though probably not very much, would be necessary as well. But if that's the position that we take, that's the material that we would respectfully suggest that your lordship should look at, and happy to answer any questions, obviously, when your lordships have seen that.
Well, if we get to that point, of course, may also be that even if we look at your material, we will then conclude it's unsuitable for us to make a decision on. But
I understand.
That's all in the future.
Yes,
Good.
I understand that.
Right.
My lord, unless there's anything... I'm sorry, my lords, I started by saying that's subject to one proviso. And it's an important proviso, which is we still have our appeal on the retrial. I'm not going to say obviously I'm not going to say anything about that, but the fact remains, if your lordships, and at some point your lordships will tell us, if your lordships determined that there should be a retrial on that appeal, then our submission would be...
Include this point.
My lord?
Include that point.
It would include this point.
It would include this point, that's all I wanted to say. And in those circumstances, we wouldn't be suggesting dividing the retrial and the remission into two separate parts.
I think, my lords, in principle, we would respectfully submit that the optimum solution would be for the board to deal with it. Can I explain why? It's because in the pleaded defence and counterclaim by R&H, they relied on identical particulars in support of, first, the claim that there was the liabilities were incurred unreasonably. And secondly, in support of their claim that there was gross negligence and breach of trust by the trustees. And one can find that from looking at the pleadings. If I can give your lordships the references. It's in the core bundle, volume 2, MS 747. Sorry, because it starts slightly earlier, the relevant passage. It's 743.
Yes.
Just to explain the structure of R&H's amended defence and counterclaim, from paragraphs 66 through to, I think, 78, in effect, the case was directed to a claim for relief, which was a declaration that the trustees were not entitled to be indemnified by reason of their unreasonable conduct. And you see, paragraph 66, the last three lines say, by reason of the matters pleaded in paragraphs 67 to 78 below, the former trustees are not entitled to any indemnity or right of exoneration from the TDT assets for any balances resulting from the accounting entries. And the accounting entries was how they described the Thorson, Glenalla, and Oscatello debts. And so they then, as I say, through 67 to 78, these are the particulars that they rely on for the unreasonable conduct.
Those are the ones that the Lieutenant Bailiff tracks through in the concluding part of his judgment.
My lord, yes. And then if one goes forward to 747, one sees the counterclaim. They repeated their defence. And then at 83, they say, by reason of the matters set out in paragraphs 70 to 76 above, the former trustees acted in breach of trust, which amounted to willful.
Same thing, yeah.
So it's the same thing. So the particulars with which the Lieutenant Bailiff was dealing were identical. And this is made clear, too, if one looks at the Court of Appeal's analysis of what they were doing in the retrial judgment. And one finds that in Volume 1. 59, so that's MS 59 too.
Yeah, it says so, paragraph 66.
It's paragraph 6, exactly, my lord. We turn therefore to consider the pleadings. They are set out in the amended defence and counterclaim for the present trustees. They are directed primarily to asserting that the former trustees had acted unreasonably incurring the loans or failing to transfer the liability for them, with the claimed result the former trustees were not entitled to indemnity from the TDT assets against the claims made by BVI companies. As we've already observed, substantially the same matters are relied on in the claim that the former trustees acted unreasonably, are also relied on as founding a claim that the former trustees acted in breach of trust in the manner of gross negligence. So they analysed the judgment of the Lieutenant Bailiff and his consideration of the particulars in support of, which were in support of both parts of their claims. And therefore, we say that the issues are substantially identical in this respect. The legal result may be different, but the factual issues are identical, because the reason why R&H lost on the grossly negligent breach of trust claim was they failed to show that there was anything that could have been done. It was a causation problem that they had. they couldn't show that the former trustees could have done anything to divest themselves of the Glenalla and Thorson liabilities. And exactly the same causation point arises in relation to this argument that's been put that the trustees' failure to divest themselves of these liabilities was unreasonable and therefore bars their right of indemnity. So, with respect, if your lordships are going to have to consider these issues of causation in response to the retrial appeal, it's the identical issues in substance.
Identical issue, but in relation to perhaps a slightly different time frame.
No, my lord. I think it's exactly perhaps I could clarify something that there is no appeal about the failure to divest the. There's no complaint now in the retrial appeal about the fact that the trustees accepted the liabilities to Glenalla and Thorson in August 2007. You find that, I think it's about paragraph 22 of the written case of R&H. And their pleaded case on unreasonable conduct then looks at the position on or after the 19th of December 2007, when the framework agreement was entered into, and the complaint is about the failure to divest former trustees of the liabilities for Glenalla and Thorson loans in respect of that temporal period, going from December 2007 through. Well, sorry? I beg your pardon. Oh, that's a question of looking at what the pleadings say, and of course the Guernsey Court of Appeal summarised the pleadings in their trial judgment 69 and in the appendix, and that's the reason why we say it is a suitable task with respect for the board to undertake, because it is in substance the same factual issues will have to be considered.
So are you going to provide your own reading guide, or wait to see what Mr. Goldsmith's looks like?
I think at the moment we can't. If the issues are the same, it looks as though you can continue to look at what's in the retrial appeal written case and responses. But when we see what Lord Goldsmith says, it may
But
be
he may
there's
develop his
Yeah.
black hole.
Yeah. But at the moment, we think in principle it must be the case that you have all the material.
Thank you. Mr. McGrater.
My lord, I think unusually on one point we have a three-way agreement that if your lordships consider that the ordinary negligence or unreasonableness question has to be decided, the position of my clients, the BVI companies, is that we would invite your lordships, if they feel able to do so, not to remit that question, but to decide it. Obviously, as far as my clients are concerned, 7 years of litigation is quite enough. We have included, for another purpose, funnily enough, in the authorities bundle, the Coventry and Lawrence decision of the Supreme Court, indicating the circumstances in which the court might exceptionally make findings where findings of fact had not been made below, including exorbitant expense and delay and so forth, if that were to happen. Now, obviously, there's a considerable overlap, as Mr. Taub has explained, with the gross negligence retrial appeal. It may be that when your lordships have look at it, they do come to a decision that they feel there has to be a retrial. We would hope not, but if there has, then it would all go back with that. But we would hope that this matter could be dealt with on the evidence. A lot of, as Mr. Taub has said, we will be adopting a lot of our submissions in writing that we make on that retrial appeal already, but we'd obviously want to review that. And obviously, I adopt what Mr. Taub has said about effectively the date range, because the case that there's any complaint about the creation of the loans has been abandoned. That's at paragraphs 21 to 22 of the present trustee's written case at MS 13751. So we're not actually dealing with the date range of August. We're actually dealing with it. So their case essentially now is you should have dealt with the loans in the framework agreement or thereafter. So it's really December 07 and through to October 08, really, in terms of the date range. My Lords, perhaps I could just add this. I won't develop it now, but obviously we say that the argument based on ordinary negligence or unreasonableness fails for a number of reasons. We say inter alia it fails because the interaction of Article 26.2 and the gross negligence exculpation clause is not as my Lord Mance described it, and we've been looking at some further authorities on that as to whether exculpation clauses would apply to the point of incurring a liability and so forth, and we would wish to have the opportunity to explain that and why we say that effectively the trustee's exculpation clause takes precedence in these circumstances, and why there is an explanation for what your Lordship put to me the other day about why does it matter if you reasonably incur an obligation on day one and then unreasonably fail to get rid of it on day two, and so on.
Well, this sounds like a slight revisiting of matters we've heard already, heard argument on, and I'm not quite sure in what form you intend, but I rather fear that you're going to reopen a whole area which will involve further written submissions from all parties. Well,
my Lord, what I was going to suggest, if your Lordship would indulge us, is that given the potential importance of the point, and we would not want there to be a danger that your Lordship's decided such an issue without a full and complete citation of the relevant authorities, that your Lordship allowed very short written submissions, perhaps limited to 5 pages per party, just to make those points.
Well, I'm sure we'd be more receptive to that, whether they should absolutely be limited to 5 pages, but I certainly think they should be limited.
Yes, well, I'm happy, my Lord, to be limited in that way, and would indeed invite a limitation, because well, it's a lengthy...
I have to hear, I mean, it slightly depends what your submissions are when we see them, but fine, and I'll hear what your colleagues say on it.
Very much obliged, Mark. And of course, just finally, we of course, the other reason why we say this line of argument fails, as I think Mr. Taub has explained, is that the present trustees failed on the causation point, that there was no loss caused to the trust if there was indeed a breach of duty. And of course, I think your Lordships have the point that if the trustees never could have divested themselves of these loans, then the only complaint can be about incurring them in the first place. And if they're reasonably incurred in the first place, that's an end of the story. Because they could never have got rid of them on Lieutenant Bailiff's findings. Got that point, my Lord. I know.
Yes. What about the suggestion of further written submissions on a subject we've already heard argument?
I'm conscious you've already heard argument. When we received your email last night, realised that there was a point, actually, which does need addressing. And so we would welcome it. I'm not going to...
Well, I think...
Can I explain very briefly, because it is potentially relevant. There, under the trust law of Jersey, there is a provision which prevents you, as a trustee, from excluding liability in the way you can in England for willful default, for everything except willful default and fraud. In Jersey, there's a provision which says you can't exclude liability for gross negligence. And so it's part of the sort of matrix which does need to be considered in the context of construing Articles 26 and Article 32. And I'm afraid it was only when we saw your email last night that we saw this. So, but they would be, I can give an assurance, they would be brief.
Yes.
Well, I'm obviously troubled by this. I mean, we're on day 4. I made it clear in the submissions that I made on Article 32 what our position was, including, and I recall saying, I think either at the end or towards the end of those submissions, that if your lordships were with us, it would be necessary to consider whether in those circumstances to remit or whether to decide the matter yourselves. And nobody had suggested, when on our case we were saying, because the Lieutenant Bailiff had decided a question of construction unreasonably incurred, we respectfully say wrongly, and because the Court of Appeal took the view that the issue didn't arise at all, they had not dealt with our case. Nobody was suggesting that wasn't the position, which is why it needs to be dealt with. I do take, I'm very concerned at the idea that my learned friends now want to drag a new point, which they had the opportunity of making in the course of argument, and dealing with that. My respectful submission is what remains to be done is to make submissions to your lordships about how to deal with the gap, whether to remit or whether your lordships should decide it yourselves. I fully understand that your lordships will want to have an idea of what the task involved is, both in terms of the extent of the task and whether it's one that your lordships are willing and feel would be right to undertake as an appellate court. Fully understand that. That is obviously an issue to be dealt with, but I would respectfully resist an attempt to reopen the debate that we've had. But that's my immediate response to my learned friends, who obviously I had no notice of that they were going to be taking that particular point.
Yes, I mean, you said at one point it was a new point, and then just said that it's actually a further submissions on an old point, which they've had their chance on.
Yes.
I mean, I think that, speaking for myself, if it is, if there is some research which Mr. McQuater either has done or now believes should be done, which would elucidate the scope of this clause, which I understand may be common, then we probably ought to have the benefit of it in writing, stated shortly, and so long as it's really no more than a development of the existing argument on an existing point, I personally don't see an objection.
Obviously, if that's your lordship's view, then...
Yes, I mean, I think he said he's going to be limited to 5 pages. I think the answer is that's a self-imposed limitation. Yes. If you howl with indignation when you see it and feel that you need 7 pages, and let us know.
I'm not at this stage at the point of worrying about the number of pages.
No,
I'm on the question whether you should be raising it at all.
There may or may not be a serious point
yes.
or serious development of the point. We need to see it, and in light of what Mr. McQuater says, I feel we should.
Of course, my lord. Would your lordships at least allow me to say this and to recognise this? If, when we've seen that, I want to repeat the submission or develop the submission that it's inappropriate for your lordships to consider that at this stage, then yes. I can do that, because as I don't know what it is, yes, I don't really know.
No, I think that's certainly open to you. If you feel feel it's totally inappropriate or goes outside the scope of an existing issue. Oh, yeah. Well, we'll have to put Mr. McQuater on terms as to what period. What time?
Time period. Well, my lord, it shouldn't take too long. I mean, we'd be happy to. We're really at the board's convenience, provided we've got at least a couple of business days, perhaps.
Well, why don't we say by Monday, close of play?
Very happy to do that, my lord.
And 5 pages in the first instance, and then Lord Goldsmith and Mr. Town and Lord Goldsmith will have an opportunity to reply. How long do you need? What are your commitments?
So he's on the same side, my lord.
Yes, he's on the same side. So Mr. Tower will just endorse it, effectively.
Yes.
Right. So, well, I think...
very quick, my lord. It's fair that we should go next, and Lord Goldsmith should have an opportunity to respond. Both.
Right. Well, would 2 days be enough after...
Close the business on Wednesday.
On Wednesday?
Yes.
Yes, and then Lord Goldsmith, well...
I have no idea, my lord, because until I know what the point is,
well,
I don't know what's required.
Why don't we, in the first instance, perhaps you could... inform the registry as to how long you need, but I would have thought that you're not going to need more than sometime in the first part of next week. After that, say
I'm away at the end of next week, so that might.
Well, why don't we say Wednesday? Close of play on Wednesday, the week after. Wednesday to Wednesday.
Wednesday to Wednesday, my lord. Yes, my lord. would your lordship still like to look at the reading list when we come back after the short adjournment?
Well, by all means, show it us. I think you're going to submit that in writing, aren't you?
Yes, it is in writing, and I'll show my learned friends, but just checking where we got to in this
Yes,
one.
no, do show it us. Then we'll. Apart from that, we simply have Guernsey 3.
Yes.
And we have slightly more time if necessary. In other words, we're more or less half an hour ahead of schedule.
Yes.
But we won't take it unless it's necessary. Good, thank you much. Resume at 2.